All right, there's a case that's before the Supreme Court today, Louisiana versus Calais. And it's not really getting the attention that it should be getting, and it is a big deal. So I just want to take a break in my regular things that I normally post right now because I think I need to talk about this. This case could decide whether Black and brown people have voting rights left in this country. And I know that sounds dramatic, y'all, but it's not, I promise. This is about the last part of the Voting Rights Act that still actually works. So here's what's going on, right? The Voting Rights Act was created back in 1965 to stop states from making it harder for people to vote just based on race. And most of these protections have been stripped over the years. But there's one piece left, and that's Section 2. That's the part that says that states can't draw voting maps or create laws that make it harder for Black and brown people to have their votes count. It's how communities have been fighting back against gerrymandering, which is when politicians redraw maps to keep certain groups out of power, essentially. And Section 2 is the reason that any of those unfair maps get challenged at all. So now Louisiana is in front of the Supreme Court today, saying something incredibly ridiculous, but also very dangerous. They're basically saying that states shouldn't be made to consider race when trying to fix racial discrimination. That makes no sense. Like, how do you fix racism without looking at race? You can't. But that's their argument, and the Supreme Court agreed to hear it. And if the Supreme Court sides with them, Section 2 won't be completely gone. It'll stop working. Because if you can't talk about race, then you can't prove racism. That's the loophole. Back in the 80s, the Supreme Court tried to make this law weaker. They said that you had to prove that racism was intentional. Like you needed someone caught saying, yeah, I did this to stop Black people from voting. And that made cases almost impossible to win. So Congress actually stepped in and said if a law ends up hurting Black voters, then that's enough. You don't have to prove impact, just intent. That's how Section 2 got stronger again. That's how Black, Native, and Latino communities started winning back fairer representation. But Calais could undo all of that progress. If Louisiana wins this case, there won't be any real federal law to protect voters of color. The part that used to stop states from changing laws without permission, that died in 2013 with Shelby County v. Holder. And this would take away what's left. And we already know what happens when that guardrail disappears. After Shelby, Texas, Alabama, and North Carolina, they all started passing voter ID laws that targeted Black and brown people. And in Pasadena, Texas, they redrew maps overnight to weaken Latino power. It's the same pattern every time. They just keep waiting until nobody's looking. So yeah, Louisiana v. Calais isn't on every headline, but it should be. Because this case is not just about one election. It's not just about one instance. This is not just one case. It's about whether our votes, our voices, really, still matter after this election is over. So if they gut Section 2, discrimination in voting won't just get worse. It'll get harder to prove. And when something can't be proven, it can't be stopped. And that's how they win quietly. Not with violence this time, but with paperwork and silence. I'm going to put a handful of legal organizations below that are working to stop this oppression. If you can donate, please do. But if you have a voice, you don't need a platform. If you have a voice, spread the word. More of us need to know about this. Authoritarian systems survive on fatigue. The way you stop them is through repetition, connection, and support for the causes made to protect us. Yeah. Land of the free.